Hello friends, we are going to continue to read the Indian Contract Act. As I had already mentioned, it is very self-explanatory. So we have certain points like catalogs and display of goods, announcement to hold auction, free distribution of articles, tender. Whether we have to decide whether these are these amounts to offer or not. Now we were on free distribution of articles, where in pursuance of a scheme adopted by ESSO, the petrol station proprietors announced that they would give the World Cup coins, one for every buyer of 4 gallons of petrol. It was held that the distribution of the coins was not a contract of sale so as to attract the provisions of Purchase Tax Act, but was only a gift. Esso Petroleum Company Limited versus Commissioner of Customs and Excise 1976, 1 WLR 1 1976. A tender is not an offer. After its acceptance, it sometimes becomes what is known as a standing offer or continuing offer. A contract takes place only after the order is placed. Reference may be made here as of an illustration Bombay case, namely Bengal Company Limited versus Homi Wadia and Company. It's 1899. It's a very old case law. In this case, the defendants entered into an agreement to supply a kind of coal from time to time required by the plaintiff for a period of 12 months. The plaintiff, in pursuance of the said agreement, placed certain orders and the defendants supplied the coal. But before the lapse of 12 months, they withdrew their offer and refused to supply the coal anymore. The plaintiffs thereupon filed the suit against them for the breach of contract. The court dismissed the suit on the ground that there was no contract. The court pointed out that it was simply a continuing offer and the contract took place only when a certain quantity was ordered. The defendants were therefore within their right to revoke. They could not, however, revoke their offer in respect of the orders actually placed. This principle was affirmed by Judicial Committee of the Privy Council in R versus Demers, 1990. The Supreme Court of India has also laid down the same principles in Union of India versus Madla Thataya. An offer should be distinguished from an invitation to receive offers. When a man advertises that he has got a stock of books to sell or houses to let, there is no offer to be bound by any contract. Such advertisements are offers to negotiate, offers to receive offers, offers to chauffeur. An offer is the final expression of willingness by the offerer to be bound by his offer should the other party choose to accept it. This should seem to become more or less obvious from the definition of proposal in section 2A, which emphasizes that there should be the expression of willingness to do or abstain with a view to obtaining the assent of the other. The offerer must have expressed his willingness to contract in terms of his offer with such finality that the only thing to be waited for is the assent of the other party. Where a party, without expressing his final willingness, proposes certain terms on which he is willing to negotiate, he does not make an offer, but only invites the other party to make an offer on those terms. This is perhaps the basic distinction between an offer and an invitation to receive offers. The Privy Council decision in Harvey versus Fassy, 1893, AC 552, has the merit of explaining the distinction. The plaintiff ordered to purchase a plot of land bumper hall pen belonging to the defendant. He made the said offer through the telegraph and asked the defendants to telegraph the lowest price. The defendant sent the reply through the telegraph, quoting the lowest price as £900. The plaintiff was ready to purchase the land at the quoted price and sent his acceptance through telegram. But the defendant refused to sell the land for $900. The plaintiff therefore sued the defendant for the breach of contract. The Judicial Committee of the Privy Council dismissed the action and observed, the mere statement agreement of the lowest price at which the vendors would sell contains no implied contract to sell at that price to the person making the inquiry. The Judicial Committee pointed out that in their first telegram, the plaintiff wanted the reply of two questions: the defendant's willingness to sell and the lowest price. The defendants did not at all answer the first question. They simply quoted the lowest price, which could amount only to invitation to an offer and not offer itself, because they did not express their willingness to sell. The principle enunciated in the above case has been approved and applied by the Supreme Court in Macpherson versus Appanna in AIR 1951. Consideration. The definition given of consideration as by Sir Frederick Pollock, which was approved by the House of Lords, is as follows: an act or forbearance of one party or the promise thereof is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. Justice Lush defined consideration as some right, interest, profit, or benefit accruing to one party for some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. Section 2D of the Indian Contract Act defines consideration thus: when at the desire of the promiser, the promisee, or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Thus, consideration may take the form of delivery of anything which has a money value, or payment of money itself, or rendering some services, or doing something which under law a person is not bound to do. Example, forbearance to sue, or a promise to do any or all of those things. Examples: forbearance to sue for ejectment is good consideration for an agreement to pay enhanced rate. I'll read it again. Forbearance to sue for ejectment is good consideration for an agreement to pay enhanced rent. A promises to pay B ₹1,000 at the end of 6 months if C, who owes the money to B, fails to pay it. B promises to grant time to C accordingly. Here the promise of each party is the consideration for the promise of the other. A promises for a certain sum paid to him by B to make good of the value of his ship if it is wrecked on a certain voyage. Here A's promise is the consideration for B's payment, and B's payment is the consideration for A's promise. Okay? So, again I'll read. A promises to pay B ₹1,000 at the end of 6 months if C, who owes the money to B, fails to pay it. Okay? B promises to grant time to C accordingly. Here the promise of each party is the consideration for the promise of the other. A promises for a certain sum paid to him by B to make good of the value of his ship if it is wrecked on a certain voyage. Here, A's promise is the consideration for B's payment, and B's payment is the consideration for A's promise. Rules governing consideration. Consideration is essential to every contract. A contract not supported by consideration is void and can only be called a gratuitous promise. In Abdul Aziz versus Musumali, 1914, a person had verbally promised to the secretary of the mosque committee to subscribe a sum of money for rebuilding the mosque. On a suit by the secretary to enforce this simple promise, it was held that the promise was not enforceable as there was no consideration in the sense of benefit to the promiser or defendant to the promise. However, a gratuitous promise is enforceable if, on the strength of the promisee suffers a detriment or undertakes liabilities. In Kedarnath versus Gauri Muhammad, 1886, A promised B to subscribe a sum of money for the construction of a town hall. On the strength of A's promise, B called for plans and entrusted the work to contractors and undertook certain pecuniary liabilities. In a suit against A, it was held that, though consideration in the sense of benefit to A was absent, still consideration in the sense of detriment to B was present and the suit was decreed. In the words of Salmond, a promise without consideration is a gift. One made for a consideration is a bargain. Consideration must move at the desire of the promiser and from the promisee or any other person. The promiser must desire the act of forbearance on the part of the promisee. Under section 2D, there must be a link between the desire of the promiser and the act of forbearance on the part of the promisee. In other words, the act of forbearance on the part of the promisee should not be at the instance of the third party. Further, consideration must proceed from the promisee or any other party, unlike in English law, where consideration must flow from the promisee only. In Chinnaya Ram versus Ramaya, an old lady, by a deed of gift, made over certain property to her daughter with the direction that the daughter should pay an annuity to A's brother. By an agreement of even debt between the daughter of A and the brother of A, the daughter promised to pay the annuity. The daughter, however, did not pay the annuity. A's brother sued the daughter. It was held that the consideration moved from A, the donor of the estate, though not from her brother, and that was sufficient consideration for the daughter's promise to A's brother, because the consideration in Indian law can move from the promisee or any other person. Hence, under Indian law, a stranger to consideration can sue, while in English law, he cannot. Consideration need not be adequate. Adequacy of consideration is the lookout of the promiser, and it is not the business of courts to adjudicate on the sufficiency or insufficiency of consideration. However, in case of plea of coercion, fraud, and undue influences is raised by a party to a contract, the adequacy of consideration will also form the part of the evidence to be considered in deciding the case. Fourth, first is consideration is essential to every contract. Second, consideration must move at the desire of the promiser and from the promisee or any other person. Third, consideration need not be adequate. Fourth, consideration must be illusory but real and competent. If a man promises to convert an ordinary paper into currency notes or to make parallel lines meet, it is illusory consideration. Consideration should also not be vague. 5. Pre-existing legal obligation. If a person is already bound by statutory or official duty to do a particular act, the performance of the act cannot be consideration for a promise. Similarly, an agreement to perform a contractual duty with a person to whom it is already owed is not made for consideration. However, a promise by A to perform an existing obligation to B will suffice to support a promise by C to A. In Shadwell versus Shadwell, 1860, A was engaged to marry B and C promised A an annuity of £150 in consideration of his marrying B. On his marriage with B, it was held that the fulfillment of A's contract with B was sufficient consideration to support C's promise to pay the annuity. Consideration must be legal or lawful. Section 23 of the Indian Contract Act states the consideration or object of an agreement is lawful unless it is forbidden by law, or it is of such a nature that, if permitted, it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral, or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. For example, A promises to obtain for B an employment in the public service and B promises to pay ₹1,000 to A. The agreement is void as the consideration for it is unlawful. 7. It may be past, present or future. Executed, executory and past consideration. Executed consideration or present consideration refers to consideration which takes place simultaneously with the promise. Thus, if C buys a watch from a watch shop and pays the price and the watch seller delivers the watch then and there, the consideration is executed since it is performed simultaneously by both parties. Executory consideration, on the other hand, refers to consideration for a promise which is to be furnished in the future. Example: A promises to paint a picture in 3 months, in return for which B promises to pay ₹100. Since the promises, which are reciprocal, have to be performed in the future, the contract is a contract with executory consideration. Past consideration. In English law, past consideration is no consideration, the only exception being the doctrine enunciated in Lampe versus Braithwaite, 1615 HOB 105. That is, a past consideration will support a subsequent promise if the consideration was given at the request of the promiser. In India, Section 2D enacts, obviously following the decision in Lampe versus Braithwaite, Hob 105 AD 1615, that if past services were done at the request of the promiser, it will be a valuable consideration for a subsequent promise of reward by the promiser. Problem: a stranger to the contract cannot sue on it. A stranger to the contract cannot sue on it. Explain. State any exceptions to the principle. The law of England is that a stranger to a contract cannot sue on it. The leading case on this point is Tweedle versus Atkinson, 1861, page 397, in which it's in IB and S 393, in which it was held that a stranger to a contract cannot sue on it. The facts of this case were as follows. The plaintiff agreed to marry the daughter of William Guy, and in consideration of this marriage, Guy and the plaintiff's father entered into a contract whereby each promised to pay a sum of money to the plaintiff. Guy failed to do so and the plaintiff sued his executors. It was held that the plaintiff was not entitled to sue. Whiteman Justice observed, "It is now established that no stranger to the consideration can make advantage of a contract although made for his benefit." Observation of Lord Haldane in Dunlop vs. Selfridge, 1915, Supreme Court, 847, also impart the same meaning, that only a person who is a party to a contract alone can sue upon it. The law of England does not recognize just quaestum testio rule. This principle has its genesis in the English common law, having been adopted by the Court of King's Bench as early as 1677 in Dutton vs. Poole. Court of King's Bench, 1677, 210. A person had a daughter to marry, and in order to provide her a marriage portion, he intended to sell a wood of which he was possessed at that time. His son, the defendant, promised that if the father would forbear to sell at his request, he would pay the daughter £1,000. The father accordingly forbore, but the defendant did not pay. The daughter and the husband sued the defendant for the amount. It is clear that the defendant gave this promise to his father. It is clear that the defendant gave this promise to his father, and it was the father alone who, by abstaining from selling the wood, had furnished consideration for the promise. The plaintiff was neither privy to the contract nor interested in the consideration, but it is equally clear that the whole object of this agreement was to provide a portion to the plaintiff. It would have been highly inequitable to allow the son to keep the wood and yet to deprive his sister of her portion. He was accordingly held liable. The common law doctrine of privity of contract is applicable in India. Also, in Jamna Das versus Ram Afta 1911, second INDCS 91, a purchaser of property contracted with the seller to pay off the mortgage debt. In an action brought by the mortgagee against the purchaser to recover the mortgage debt, it was held by the Privy Council that he was not entitled to force the contract so as to compel the purchaser to pay off the debt because he was not a party to the contract. The above rule was applied by Rankin, Chief Justice, in Krishnalal versus Pramila Bai Devi, AIR 1928. The learned Chief Justice observed that although the definition of consideration contained in Section 2D of the Contract Act is wider than in English law, yet there is nothing in this Section 2 to encourage the idea that contracts can be enforced by a person who is not a party to the contract. Exceptions. The exceptions to the above rules are as follows: where a trust is created in favor of a stranger, where provision is made in the marriage settlement, where provision is made in a partition or family arrangement for maintenance or marriage of a female member or minor, where a charge is created in favor of a stranger, where there is a direct agreement to pay to the defendant who constitutes himself as the agent of the third party. Illustration of exception. Privity of contract. The illustration of the first is provided by the case of Candy versus Candy, 1880, 16 CHD 125, in which Gilton Lord Justice observed, if the contract, though in form, is with A, and it is intended to secure a benefit to B, so that B is entitled to say he has a beneficial interest in Sestri Goe Trust under that contract, then B would, in a court of equity, be allowed to sue upon and enforce the contract. The same view is held by the Indian High Courts, Wide 53 Madras 270, and in Gorakh Ram Lakshmi AIR 1953, Supreme Court 443. The leading case on this point is that of Khwaja Muhammad Khan versus Hussaini Begum, 37 IA 152. In this case, the parents of the bride and the bridegroom agreed that the plaintiff bride would be entitled to rupees 100 per mention in Kharcha Pandan, and the contract was held binding upon the defendant, and the plea that the third party cannot sue upon the contract was negatived. The above ruling of Khwaja Muhammad Khan's case had been applied to the case of partition and family arrangements also, where provision is made for minors, etc. Dhankar versus Sarla Devi ILR 1946, ALL 756. This covers cases in which a charge is created in favor of a stranger. Thus, in Abdul Ghaffur versus Muhammad Salim 42, the above principle was affirmed. It appears that the law is that even though under the Indian Contract Act the definition of consideration is wider than in the English law principle generally applicable in India, with the effect that only a party to the contract is entitled to enforce the same. But where it is found that an obligation in equity amounting to a trust arising out of such contract did exist, the beneficiary had the right to sue. Narayani Devi versus Tagore Commercial Corporation Limited, AIR 1973, CAL 401. This covers cases in which the promisee agrees directly to pay a third party. In the case of Venkata Reddy Naidu versus Narasimha Rao 1935, Madras 105, the purchaser of a mortgaged property undertook to pay the mortgagee. It was held that the mortgagee could recover from the purchaser. It is clear from the above that so far as the exceptions to the rule are concerned, they are similar, both under Indian and English law. So far as the rule is concerned, the Indian High Courts are not unanimous on the point. The preponderance of opinion among the High Courts in India is that the English rule of Twiddle versus Atkinson, 1861, IB and S 393 applies to India. The Privy Council in Jamna Das versus Ram Avatar Pandey 37 IS 77 has finally settled the point. So we're going ahead. Types of agreements. All agreements are classified into valid, void, voidable, enforceable, and illegal. Valid agreements. These are agreements that are enforceable at law. Such an agreement is fully operative in accordance with the intention of the parties and the law. Such an agreement satisfies all the conditions of a valid contract under the Act. Void agreements. A void agreement is one which has no legal effect at all and is therefore not enforceable at law. Thus, agreements of which the object of or consideration is unlawful, or which are in restraint of trade or of marriage or of legal proceedings, or which are by way of wager, are all void. No legal rights flow from such an agreement, and consequently, no action can be taken under such an agreement in a court of law. In the eyes of law, there is no agreement at all. Such agreements are void ab initio, that is, void from the very beginning. It will thus be seen that there cannot be a void contract. A contract is always an agreement which is enforceable at law, and therefore to speak of a void contract involves a contradiction in terms. Third, voidable agreements. Voidable agreement is one which is valid as long as it is not avoided by the party entitled to do so. Thus, it is an agreement which is enforceable at law at the option of one of the parties to such agreement, but not at the option of the other. Thus, I'll read that again. A voidable agreement is one which is valid as long as it is not avoided by the party entitled to do so. Thus, it is an agreement which is enforceable at law at the option of one of the parties to such agreement, but not at the option of the other. Thus, agreements induced by coercion, undue influence, fraud, or misrepresentations are voidable. It is for the party upon whom fraud, etc., has been practiced to set up such fraud, etc., and have the agreement set aside by the court. If he does not, the agreement stays as a legal binding contract. Unenforceable agreements. An otherwise valid contract may be unenforceable at law if some rule of law renders it incapable of proof because of some technical defect, example, a promissory note which is unstamped or not sufficiently stamped. Such a contract is otherwise valid but cannot be proved and enforced in a court of law. agreements. These are agreements which are void because they are against the law. Thus, an agreement to buy smuggled opium would be void as it is illegal. Illegal and void contracts distinguished. The term illegal is narrower in meaning than the term void. All illegal contracts are void, but all contracts that are void are not necessarily illegal. Example, an agreement in restaurant of trade is void but not illegal. A void agreement is destitute of legal effect when it is proved to be so. A void agreement is destitute of legal effect when it is proved to be so, but an illegal one is so ab initio. The distinction between a void and illegal contract is important as regards to collateral transactions, because an agreement which is collateral to an illegal agreement cannot be enforced, whereas transactions collateral to a void agreement are not affected. All contracts are agreements, but all agreements are not contracts. Section 10 of the Indian Contract Act provides, what agreements are contracts? All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in India and not hereby expressly repealed. Repealed means to make a law so longer valid. And not hereby expressly repealed, by which any contract is required to be made in writing or in the presence of witnesses, or any law relating to the registration of documents. In order to constitute a contract, both the parties must consent to the agreement. Steel Authority of India Limited versus Salem Stainless Steel Suppliers, AIR 1994, Supreme Court 1415. A contract comes into existence only when all the terms and conditions have been finalized. In order to constitute a contract, both the parties must consent to the agreement. Steel Authority of India Limited versus Salem Stainless Steel Suppliers, AIR 1994, Supreme Court 1415. A contract comes into existence only when all the terms and conditions have been finalized. If the facts of a particular case show that the execution of a written contract was a condition precedent for coming into force of the contract between the parties, then it cannot be said that any concluded contract in absence of a written contract being executed has come into force between the parties. JK Industries Limited versus Mohan Investments and Properties Private Limited, AIR 1992, DEL 305. While defining the term contract, Section 2H has made it clear that contract is an agreement enforceable at law. An agreement is an essential element for constituting a contract. Therefore, it can be said that all contracts are agreements, but converse is not true. It means all agreements are not necessarily to be contract. Only such agreements which are enforceable at law are contracts, others are not. From the definition of the term contract, it is clear that every kind of agreement is not contract. An agreement which creates legal rights or obligations, liabilities between the parties, and which has some value in the eye of law is a contract. Certain agreements are not enforceable at law. For example, A promises to pay ₹100 to B if B kidnaps X. This agreement is not enforceable at law, although there is a promise as well as consideration, because the agreement being unlawful is not enforceable at law. Therefore, all contracts are agreements, but all agreements are not contracts. The definition of the term contract as given in Section 2H is further expressly clearly or become more clear by studying Section 10 of the Act. It is correct that the agreement must be enforceable at law only then it shall become contract. But only this expression does not make it clear as to what other factors and elements are essential to get the agreement enforced. After going through section 10, following can be detailed as essential elements of a valid contract. Agreement. It must be an agreement. In other words, there must have been offer and acceptance. There must be a proposal to which an unqualified acceptance has been given. It is not necessary that proposal should be made to a specific person. It will do even if it is addressed to nobody in particular. Carlyle versus Carbolic Smoke Ball Company, 1893, 1 QB 256. This case lays down that general offer can be made, but a mere intimation of one's willingness to do business, as in the case of an advertisement to sell goods by auction which is afterwards, is not enough. Harris versus Nickerson, 1873, LR 8 QB 286. If there is neither proposal nor an unconditional acceptance, there is no contract. The minds of both the parties must be addendum, that is like meeting of minds. Parties. The parties must be competent to contract. The parties should be of the age of majority and sound mind and not disqualified from contracting by any law to which they are subject. Certain persons are incapable of binding themselves by a promise or of enforcing a promise made to them. The incapacity may arise from political status or mental deficiency or artificial personality. Free consent. The agreements must have been made by the free consent of the parties. Section 32 to Section 22. They must have agreed to something in the same sense, and the consent of a party must not have been obtained by coercion, that is undue influence. 1. Coercion, undue influence, fraud and misrepresentation or mistake. Consideration. The agreement must be for a lawful consideration and with a lawful object. The agreement must be for a lawful consideration and with a lawful object. Section 12, 23 to 25 and 56. Consideration is said to be unlawful if it is forbidden by law, or 2. It is of such a nature that if permitted it would defeat the provision of any law, or it is fraudulent. 4. It involves or implies an injury to the person or property of another, or the court regards it as immoral or opposed to public policy. Exception. There are certain conditions enumerated under Section 25 under which a contract without consideration is treated to be a valid one. To be void, the agreements must not have been expressly declared to be void. Section 24 to 30 and 56. Under this Act, the following agreements are declared void, where both the parties to an agreement are under a mistake of fact essential to the agreement. Section 20. Or agreement in restraint of the marriage of any person other than minor. Agreement in restraint to trade. Agreement in absolute restraint of judicial proceedings. An agreement the meaning of which is uncertain and incapable of being certain. Section 29. Agreement by way of wager. Section 30. Agreement to do an act which is impossible in itself or which subsequently becomes impossible without default of a party. Section 56. Other legal requirements. An agreement must fulfill the requirements or formalities necessitated by any particular law. An agreement must be in writing, attested and registered, if so required by any law in force in India. Certain agreements, such as agreement to pay a time-barred debt, or agreement to transfer of immovable property, or agreement to refer the matter to an arbitrator in case of disputes, are such agreements which must be reduced to writing and registered before they can be legally enforced. Agreement by way of wager. Section 30. Agreement to do an act which is impossible in itself or which subsequently becomes impossible without any default of a party. Section 56. Other legal requirements. An agreement must fulfill the requirements of formalities necessitated by any particular law. An agreement must be in writing, attested and registered if so required by any law in force in India. Certain agreements such as agreement to pay a time-barred debt, or agreement to transfer of immovable property, or agreement to refer the matter to an arbitrator in case of disputes, are such agreements which must be reduced to writing and registered before they can be legally enforced. Contract without consideration. When valid. Normally, a contract made without consideration is void, but Section 25 of the Indian Contract Act provides an exception to this rule. It says, an agreement made without consideration is void unless it is expressed in writing and registered under the law for the time being in force for the registration of documents and is made on account of natural love and affection between parties standing in a near relation to each other, or unless it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promiser, or something which the promiser was legally compellable to do, or unless it is a promise made in writing and signed by the person to be charged therewith, or by his agent, generally or specially authorized in that behalf, to pay wholly or in part a debt of which the creditor might have enforced payment but for the law for the limitation of suits. In any of these cases, such an agreement is a contract. Explanation 1. Nothing in this section shall affect the validity, as between the donor and donee, of any gift actually made. An agreement to which the consent of the promiser is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promise was freely given. Contract without free consent is valid. A contract is not valid without free consent according to Indian Contract Act. A free consent is defined in Section 14 of the Act as consent is said to be free when it is not caused by coercion as defined in Section 15, undue influence as defined in Section 16, fraud as defined in Section 17, misrepresentation as defined in Section 18, mistake subject to the provision of Section 20, 21 and 22. What are these? Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. Consent is said to be so caused when it would not have been given but for the existence of such coercion, undue influence, fraud, misrepresentation or mistake. Distinction between void, voidable, illegal and unenforceable contracts. The difference between void and voidable contract is as under. Void contract. No obligation or right arises or accrues to parties to the contract from a void contract. Such contracts are not covered by law. Voidable contract. A voidable contract continues at the option of one party. It is the desire of one party either to rescind it or continue. It is enforceable at the option of one party and is covered by law. A void contract can give rise to no legal liability since transaction is nullity. A voidable contract remains valid until rescinded. A void contract cannot confer any right. A voidable contract confers enforceable rights till it is not rescinded. The contract becomes void when it ceases to be enforceable. A contract becomes voidable only when consent to agreement is obtained by coercion, undue influence, fraud, or misrepresentation. The most important part of a voidable contract is a voidable contract continues at the option of one party. It is the desire of one party either to rescind or continue. It is enforceable at the option of one party and is covered by law. Going ahead, the contract becomes void when it ceases to be enforceable. A contract becomes voidable only when consent to agreement is obtained by coercion, undue influence, fraud, or misrepresentation. A void contract cannot be made valid by parties to the contract by their consent. A voidable contract can be made valid by the party who has a right to rescind it by giving up his right of rescinding it. Void contract is defined in section 2I, and such contracts have been detailed in section 24 to 30, 32, 35, 36 and 56 of the Act. Voidable contract is defined in section 2I, and such contracts have been defined in section 19, 19A, 38, 39, 55, 64 and 66 of the Act, as also section 14 to 18 of the Act. The distinction between void and illegal contract is as under. Void contract. A void contract is merely voidable. The parties to a void contract are not necessarily liable to penalty. The parties to an illegal contract are liable to be penalized. A void contract is entered into on account of special reasons. Voidable contracts are also entered into on account of special reasons, but these reasons differ from the reasons which make a contract void. In a void contract, collateral contracts are recognized. In an illegal contract, the collateral contracts are also illegal. The distinction between illegal and unenforceable contract is as under. Illegal contract. If the consideration and object of the contract is not lawful, the same will be termed as illegal contract. Section 23 of the Indian Contract Act mentions what considerations and objects of an agreement are lawful and what not. All illegal contracts are void, but all that are void are not necessarily illegal. For instance, a wagering agreement is indeed void but not illegal. An illegal contract is like contagious disease and is fatal not only to main contract but to collateral contracts as well. Unenforceable contract. An unenforceable contract is a valid contract, but that cannot be enforced because of certain technical defects, for example, by want of stamp, by bar of limitation, by breaking of war between the nations of trading parties, etc. It is valid, but in English law, it is valid but incapable of proof. Such type of contracts in India are also termed as void contracts, but in English law they are regarded as unenforceable contracts. But for enforceability, this kind of contracts are as good as valid contracts. Lack of certain technical qualifications, these contracts contain all those qualities which a valid contract possesses. However, the fate of these contracts is similar to that of void contracts. Free consent, coercion, undue influence, fraud and misrepresentation. Free consent. Section 13 enacts 2 or more persons are said to consent when they agree upon the same thing in the same sense. Section 14 defines free consent. Thus, consent is said to be free when it is not caused by coercion, as defined in Section 15, undue influence as defined in Section 16, fraud as defined in Section 17, misrepresentation as defined in Section 18, mistake subject to the provisions of Section 20, 21 and 22. Consent is said to be caused when it would not have been given but for the existence of such coercion, undue influence, fraud, misrepresentation or mistake. Coercion. According to Section 15, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code 45 of 1860, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. It is immaterial whether the Indian Penal Code 45 of 1860 is or is not in force in the place where coercion is employed. Duress in English law corresponds to coercion in Indian law, but coercion has much wider amplitude. Difference between coercion and duress. Coercion can be employed against any person, including a stranger. Duress can be employed only against the life or liability of the other party to the contract or the members of his family. Coercion. Immediate violence did not arise from coercion. Duress must be such as to cause immediate violence. Coercion need not be such as to affect a man with ordinary strength of mind. Duress must be such as to affect a man with ordinary strength of mind. Coercion may be employed against any person. Duress may be employed only by the party to the contract or his agent. Unlawful detention of goods amounts to coercion in Indian law. It is not duress under English law. In Ranganayakama versus Alwar Chetty, 1889, 13 Madras 214, the refusal by the relatives of a deceased person to permit the cremation of his body until the deceased wife gave consent for adopting a boy was held to amount to coercion. In Muthaiya Chettiar versus Karuppan Chetty, 1927, 50 Mad 786, an agent refused to hand over the account books, bonds, etc. of the business to his successor. An agent refused to hand over the account books, bonds, etc. of the business to his successor agent unless the principal gave him a release of all liabilities during the term of his agency. The principal did so, but later succeeded in the suit to declare the release deed as vitiated by coercion. A mere threat by a person to prosecute another would not amount to coercion, as there must be a contract made under threat, and that contract should be sought to be avoided because of coercion. A contract flawed by the element of coercion is a voidable contract. Undue influence. Section 16 defines undue influence as a contract is said to be induced as undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. In particular, and without prejudice to the generality of the foregoing principle, a person is deemed to be in a position to dominate the will of the other, where he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to the other, or where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reasons of age, illness, or mental or bodily distress, where the person who is in a position to dominate the will of another enters into a contract with him, and the transaction appears on the face of it or on the evidence adduced to be unconscionable, the burden of proving that such contract was not induced by undue influence shall be upon the person in a position to dominate the will of the other. I'll read that paragraph again. Where the person who is in a position to dominate the will of other enters into a contract with him, and the transaction appears on the face of it or on the evidence adduced to be unconscionable, the burden of proving that such contract was not induced by undue influence shall be upon the person in a position to dominate the will of the other. Nothing in this subsection shall affect the provisions of section 111 of the Indian Evidence Act 1872. Illustrations. A. Having advanced money to his son, B. during his minority, upon B's coming of age, obtains by misuse of parental influence a bond from B for a greater amount than the sum due in respect of the advance. A. employs undue influence. A man enfeebled by disease or age is induced by B's influence over him as his medical attendant to agree to pay B an unreasonable sum for his professional services. B employs undue influence. A man, I'll read it again. A man enfeebled by disease or age is induced by B's influence over him as his medical attendant to agree to pay B an unreasonable sum for his professional services. B employs undue influence. Thus, undue influence or constructive fraud, as it is sometimes called, is used to cover all cases where one party to a contract has not received a fair deal. It is also presumed in certain cases like parent and child, guardian and ward, trustee and beneficiary, spiritual master and disciple, lawyer and client, doctor and patient. It is clear from the definition of undue influence in section 16 that contracts flawed by the element of undue influence fall into two categories. Where no special relationship exists between the parties to a contract, where a special relationship exists between parties to a contract. So there are two. It is clear from the definition of undue influence in section 16 that contracts flawed by the element of undue influence fall into two categories. 1. Where no special relationship exists between the parties to a contract, whereas there is a special relationship exists between the parties to a contract. In the case of contracts falling in category A, that is, where no special relationship exists between the parties to a contract, the party influenced must prove 1. The other party was in a position to dominate his will, and 2. That the contract was extremely unfair and gave the other party unfair advantage. In the case of contracts falling in category where relationship exists between the parties to a contract, undue influence will exist. The leading case on the subject is Alcard vs. Skinner, 1887, CH D 145, 183. Miss A joined a sisterhood and was under the spiritual subordination of the defendant for some time, during which period she gave away a bulk of her properties to the sisterhood. About 6 years after leaving the sisterhood, she sued for recovery of all these properties. It was held that, though the relationship between herself and the defendant raised a presumption of undue influence, her conduct in keeping quiet for 6 years after any such influence ceased to exist amounted to an affirmation of the gift made by her, and that she could not therefore recover her properties. Further, in John Mackenzie versus Bank of Canada, 1934 AC 468-475, the Privy Council held, there is no presumption of undue influence between husband and wife. In cases where it is necessary to disprove the presumption of undue influence, it should be proved that the protected person had independent advice entering into the transaction and not subsequently. However, in Tungabi Kumlochkar versus Yashwant Dinkaroj 71 IA 184, 1945, Bombay 1980, 1945, APC 810. When an illiterate wife who could only sign mortgaged her entire properties in favor of a creditor in obedience to her husband's wishes for an advance of loan to her husband, who was at the end of his own resources and managing his wife's properties, it was held that the wife was not a free agent and that the creditor, who had notice of all the facts which raised the presumption of undue influence, was in no better position than the husband who exercised it, and that the creditor could not enforce the mortgage. In dealing with cases of undue influence, the court should consider the following four important questions. Viz. Whether the transaction is a righteous transaction, that is, whether it is a thing which a right-minded person might be expected to do, whether it was improvident, that is, whether it shows so much improvidence as to suggest the idea that the donor was not master of himself and was not in a state of mind to weigh what he was doing, whether it was a matter requiring a legal advisor, whether the intention of making the gift, if any, originated with the donor, Muhammad Baksh versus Hussaini Bibi, 15 IA 81. I'll stop here right now and I'll continue in my next video. I'll start from unconscionable transactions. Please do like, subscribe and share my channel, and I'll come back to you with more legal, business, other kinds of books which I will read out. Thank you. Bye-bye.